Can Ripple beat the SEC? When will Ripple present new arguments in its defense? How much will XRP cost after the trial ends? We will answer these questions in today's video. In the meantime, subscribe to the channel and we're getting started. Attorney Deaton achieved a significant victory on behalf of LBC token holders and the whole crypto sector in the just-finished hearing between LBRY and the SEC conducted yesterday at the Warren B. Rootman United States Courthouse in New Hampshire. Deaton, who acted as amici counsel for tech journalist Naomi Brockwell, successfully persuaded the judge that LBC secondary market transactions are not securities. In order to avoid giving clarification for LBC, the SEC sought an injunction that does not differentiate between LBRY, the company's management, and consumers. Attorney Deaton remarked that the injunction was imprecise and wide, forcing him to seek clarity for Brockwell and other LBRY users' LBC secondary market activities. The inventor of crypto law said that he referred to a paper prepared by commercial contract lawyer Louis Cohen that examined all security cases in the United States since Howard. According to Deaton, during Cohen's research of security cases in the United States, no court ever acknowledged that the underlying asset was a security. The article states that your ruling seems like you may be suggesting that LBC is security in and of itself. Deaton said to the judge in court, "If you don't intend that, judge, then we need to explain it." After some back and forth, the judge said that he is not inclined to issue an injunction, according to Deaton. He went on to say that the judge's declaration is a huge victory since the court will not issue an injunction against LBRY users. Deaton said that he got the Securities and Exchange Commission to admit on the record that LBC secondary market transactions are not securities. Hearing on LBRY, the stakes for all crypto. Several Bitcoin fans have praised Deaton's efforts in the LBRY case, which might be employed in future crypto-related matters such as Ripple v. SEC. In a tweet today, Hogan law firm partner Jeremy Hogan praised Deaton for pressuring the SEC to state on the record that LBC as a token is not a security. The SEC acknowledged on the record that the token itself is not a security at the SEC's UV LBRY hearing. Excellent work, Mr. Deaton. Furthermore, Fox Business journalist Eleanor Terrett praised Deaton, noting that no one battles harder for the Bitcoin sector than the creator of crypto law. Takeaways. 1. In the Hellbrackham case, the SEC of attorneys admitted author that secondary market transactions of LSU tokens do not constitute a security. 2. No one is more dedicated to the crypto community than Jan is more dedicated to the crypto community than consider how simple it would be for the SEC if it weren't for him. LBRY has the following message for SEC. Ideal for the SEC. Ripple's general counsel Stuart Alderoty has reacted to a recent Bloomberg article titled "Fight to Regulate Crypto at Crossroads as Ripple Ruling Looms." The article, published yesterday, explains how an upcoming Ripple v. SEC lawsuit ruling will determine which federal agency between the SEC and CFTC should regulate the industry. Bloomberg, in reference to the lawsuit between the SEC and RIPPE, said, "An upcoming ruling in New York federal court could help determine the answer, along with the fates of numerous crypto investors and companies. The case hinges on whether a prominent digital token should be treated as a security, which would fall under the Securities Exchange Commission jurisdiction." The leading media outlet cited comments from former SEC's legal representatives, with the majority saying that the implosion of cryptocurrency exchange FEX will determine the outcome of the Ripple lawsuit. Reacting to the article, Alderoty said irrespective of how Bloomberg dissects the lawsuit, the experts all agree that the outcome of the case will affect the future of cryptocurrencies in the United States. No matter how you dissect it, the experts agree. The outcome of the Ripple case will likely have a significant impact on crypto's future in the USE, he said. The ongoing Ripple case has captured much attention from the XRP community and other cryptocurrency investors, thus suggesting the significance of the lawsuit in the U.S. crypto industry. There is an ongoing debate over who should regulate the cryptocurrency industry, with top industry players like Ripple's CEO Brad Garlinghouse backing the CFTC to emerge as the appropriate regulator for crypto. The SEC, under the leadership of Gary Gensler, is trying to position itself as the cop on the beat for the emerging market. Carol Goforth, a professor at the University of Arkansas School of Law specializing in fintech regulation, said in the Bloomberg piece that should the SEC win the lawsuit, the regulator would claim jurisdiction over most crypto assets. However, a win for Ripple could reduce the SEC's claim over becoming the regulatory watchdog for crypto. It bears mentioning that the SEC has faced criticism from crypto stakeholders over its regulatory approach in the crypto sector. Industry players, including Alderodi, have accused the SEC of preferring enforcement instead of clarifying rules. Aside from crypto enthusiasts, Arthur Jacoby, a former SEC attorney, has slammed the SEC for its regulatory approach in the crypto space. Instead of engaging in transparent and public rulemaking with industry comments, the SEC has chosen to mark its digital asset territory via the federal court system, Jacoby noted. In response to this criticism, Gensler has maintained that existing financial market rules are clear. Meanwhile, a decision in the Ripple v. SEC lawsuit is expected to be given in the first half of the year, as both the SEC and Ripple are asking Judge Annalisa Torres to rule in their favor. The long-running legal brawl between Ripple and the U.S. Securities and Exchange Commission edges close to an end. In a tweet today, top U.S. defense lawyer James K. Filan informed his over 138 followers that as of January 19, 2023, everything is briefed in the lawsuit. This suggests that the parties, Ripple and the SEC, have made the necessary filings, including motions for summary judgment and motions to seal all materials relating to the summary judgment motion. Filan's tweet comes as part of efforts to update the XRP community on the scheduling updates of the lawsuit. An excerpt from the attached image read, "Now we wait." Judge Annalisa Torres is currently reviewing the multiple briefs filed by the parties before making a final decision. Reacting to the tweet, excerpt community members took to the comment section to express gratitude to Filan for keeping them updated throughout the lawsuit, which has lasted for over 2 years. Attorney Jeremy Hogan, a partner at Hogan Law Firm, was among those who expressed gratitude to Filan for his efforts in keeping the crypto community updated. XRP community attorney John Deaton also reacted to the latest scheduling updates shared by Filan. Deaton referred to Filan's latest Ripple v. SEC lawsuit tweet as the best update ever. In December 2020, the SEC dropped a bomb on the crypto industry by suing Ripple and 2 of its executives, Brad Garlinghouse and Chris Larson. The Securities and Exchange Commission claimed that Ripple and its execs sold unregistered securities in the form of XRP. The case, which Forbes dubbed the cryptocurrency trial of the century, is expected to set a precedent for the future of the U.S. crypto market. A win for Ripple could pave the way for regulatory clarity in the United States. However, a ruling in favor of the SEC could give the regulator a powerful weapon to go after other cryptocurrency projects. In previous updates, Filan has predicted that Judge Torres would likely make a final decision on the case before the end of March 2023. Meanwhile, Ripple's CEO recently told CNBC that he expects a final resolution of the company's legal brawl with the SEC to happen in the first half of this year. Garlinghouse added that he is confident about the outcome based on Ripple's position with the law. The case is now fully briefed in front of the judge. We are optimistic that this will certainly be resolved in 2023, maybe the first half. We'll see how it plays out from here. But I feel very good about where we are relative to the law and the facts, he remarked. As reported by the Crypto Basic in Davos, Ripple CEO said that people will be stunned at the SEC's behavior when Hyman's emails come to light.